Thank you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and our recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with the contact information you'll see on the last slide. All right, just a little bit about us. We are a Washington, D.C.-based firm and provide services for federal contractors. This ranges from market analysis reports to proposal writing and also post-award compliance. More information is on our website, so please visit us there. All right, our speaker today is Elizabeth Jochum, and she's going to be going over pre-award protests, when, why, and where. Thank you for joining us today, Elizabeth, and I'm going to go ahead and hand it over to you.
Great, thank you. Good morning, everyone, and thanks for participating today in this webinar on pre-award protests. As Mallory mentioned, my name is Elizabeth Jochum, and I'm a government contracts partner at Smith Pachter, with much of my practice focusing on bid protests. Pre-award protests, as the name implies, are protests filed before an award is made under a solicitation. There are two primary types of pre-award protests. Mallory, you can go to the next slide. It'll summarize these primary types. Generally, when people refer to pre-award protests, they're talking about solicitation challenges. These protests don't deal with an alleged error in the evaluation of the protester or anything specific to the protester's bid or the awardee's bid, but rather they allege that something is wrong with the solicitation itself. And commonly, these challenges include allegations that the requirements or specifications of this solicitation are overly restrictive or ambiguous. Allegations that solicitation provisions are unduly restrictive of competition focus on weighing the agency's needs with the impact of restrictive requirements on the competitive field. While agencies have very broad discretion to assess their needs and dictate how those needs are met, restrictive specifications must be grounded in a reasonable basis. In other words, they must be related to the agency's actual needs. Unduly restrictive specifications can cover everything from technical requirements to the number of key personnel required. But the question will ultimately turn on whether or not the specification is reasonably necessary to meet the agency's needs, particularly where it has a significant detrimental impact on competition. Agencies do tend to have broad discretion in this area, but that discretion is not unlimited, and both GAO and the Court of Federal Claims have sustained protests alleging unduly restrictive requirements in recent years. Protests alleging ambiguous solicitation provisions are another relatively frequent basis for a pre-award protest. We'll discuss the timing of pre-award protests a bit later, but it's important here to raise the issue of patent versus latent ambiguity. At all the available protest venues, a solicitation improprieties that are apparent prior to the time set for receipt of proposals must be protested before that time. This reality has created a whole body of case law, both at the court and at GAO, regarding patent versus latent ambiguity. If a solicitation provision is patently ambiguous, meaning that the ambiguity is apparent on the face of the solicitation, then those provisions must be challenged prior to the submission of proposals. Protesters who allege ambiguity in a post-award protest have to demonstrate that the ambiguity was latent, meaning that the protester had no reason to believe that any reasonable interpretation other than their own existed. Bidders tend to be very hesitant to file pre-award protests alleging ambiguous solicitation provisions. And it's quite common for bidders to be aware of an ambiguity and decide to pick the interpretation that best suits them and bid on the contract despite the ambiguity. But it's worth noting that if that interpretation is incorrect, or if the bidder is otherwise displeased with the outcome of the evaluation, it will not be able to raise that ambiguity in a post-award protest. As we'll discuss a bit later, if ambiguities can't be resolved through Q&A, they can be particularly appropriate for an agency-level protest. Solicitation challenges also include challenges to the evaluation criteria or other ground rules of the competition. And these can include allegations that the evaluation criteria is unreasonable or likely to produce a misleading result. These come up most commonly with regard to the proposed price or cost evaluation criteria. For example, a protester can allege that there is no reasonable relationship between the solicitation price or cost evaluation method and the likely cost of performance, or that the price evaluation criteria will otherwise not allow the agency to compare the relative costs of proposals and determine whether one will be more or less costly than another. The other primary type of pre-award protest, other than solicitation challenges, is challenges to the agency's competitive range determination, which involves removal of the protester from the competition. Substantively, these protests tend to be very similar to post-award protests, except that they tend to focus more on the evaluation of the protester relative to a group of bidders rather than just one, the awardee. We can go to the next slide, please, Mallory. Thank you. Pre-award protests also include a range of other challenges. A protester can allege that an agency plans to improperly issue a sole source award. These protests are commonly triggered by the issuance of a justification and approval document announcing the agency's intention to issue that sole source award. Potential bidders can also file pre-award protests alleging that the agency has failed to meet its obligations under the Rule of Two to set aside the contract for small businesses or other socioeconomic groups like hub zone businesses or service-disabled veteran-owned businesses. Under the Rule of Two, an agency must set aside a contract for small businesses if it reasonably expects two or more qualified businesses to submit offers at fair market prices. An interested small business can protest if that rule is not followed and the solicitation is released on a full and open basis or an otherwise unrestricted basis. Another potential pre-award protest ground is that an anticipated task order that's being solicited is outside the scope of a base contract. This pre-award protest ground raises some really interesting jurisdictional issues because there are significant limitations on both the Court of Federal Claims and GAO's ability to hear protests related to task orders. But in many cases, a protest alleging that a task order solicitation is outside the scope of the base contract and therefore should have been issued as a standalone contract, for example, can be found to have jurisdiction where other task order protests do not. Some protests alleging organizational conflicts of interest are also properly filed in the pre-award context. In particular, at GAO, if a protester is on notice that a likely competitor has an OCI and that the agency has determined that the competitor is eligible for award, regardless of that alleged OCI, the protester must file any protest of that determination in the pre-award context. Next slide. Like post-award protests, pre-award protests can be filed in one or more of three possible venues. First, they can be filed with the procuring agency. An agency-level protest only requires a letter to the contracting officer describing the legal and factual basis for a protest. Either the protester itself or counsel can send that letter. The protester can, but does not have to, request review at a level above the contracting officer. If it does not, then the contracting officer, him or herself, will decide the protest. After filing the initial protest, there's generally not additional discovery or briefing that occurs. The decision-making essentially occurs behind closed doors at the agency after submission of the initial filing by the protester. And under the regulations, the agency must use best efforts to resolve agency-level protests within 35 days. Pre-award agency-level protests are more common and at least anecdotally more successful than agency-level post-award protests. Agency protests in this context can be an effective way of raising the necessary challenge in a timely way without worrying about antagonizing a potential customer. Essentially, you're keeping the qualms that you have with the solicitation between you, the protester, and the agency itself. This can be a logical next step if, for example, you've tried and failed to have the issue resolved through Q&A, or if progress was being made, but the deadline for proposals is approaching. Also, it's worth noting that if an agency level pre-award protest is denied, you can file a subsequent protest at GAO and still get an automatic stay of award, assuming that award has not yet been made. Next slide. Pre-award protests can also be filed with the Government Accountability Office, GAO. GAO is the most popular venue for both pre-award and post-award protests. It's a relatively affordable venue that allows protesters to have their protest decided by an independent third party in a relatively efficient timeframe. GAO must resolve its protest by issuing a decision within 100 days, and many protests are resolved sooner than that. GAO protests are drafted as letters to GAO with the contracting officer CC'd. They're filed electronically with GAO through its online docketing system and are served on the contracting officer by email. In a GAO protest, unlike an agency protest, the agency is represented by agency counsel and responds to the protest by producing relevant documents, a contracting officer's statement of facts, and a legal brief as part of a production called the agency report. The protester then has the ability to respond to that agency report and file any supplemental protests that arise based on the information received in that report. So a little more extensive and involved than an agency level protest, but also more information becomes available to the protester or its counsel. Next slide. Finally, pre-award protests can be filed at the Court of Federal Claims. This is the least common pre-award protest venue for two primary reasons. First, it's generally the most expensive of the three venues, and second, because there's no automatic stay of contract award, as we'll discuss a bit further. But it's worth noting that the case law at the Court of Federal Claims can be different than the case law at GAO. So if research is showing that the GAO case law on your issue is not particularly favorable, it's worth researching whether it's substantively different at the court and considering protesting there. There's also an impression by some of us in the protest counsel community that at least some judges on the court are more willing than GAO attorneys to change existing case law or make new case law in areas that have not yet been considered. Next slide. As with post-award protests, timeliness is absolutely key to pre-award protests. Missing the deadlines for filing can result in dismissal of the protest. In general, and in all three venues, solicitation challenges must be filed prior to the time set for submission of proposals or quotations. This encompasses the broad range of challenges to the terms of the solicitation, from unduly restrictive requirements to improper bundling to failure to set aside for small businesses. This deadline is generally triggered by the deadline for filing of initial proposals, but if an amendment to the solicitation introduces the alleged impropriety for the first time, then the subsequent deadline for submission of proposals or amended proposals will trigger the protest filing deadline. For issues that arise after proposals have been submitted, particularly challenges to the protester's removal from the competitive range, the protest must be filed within 10 days of the required pre-award debriefing. If no debriefing is required, then the protest must be filed no later than 10 days from when the basis of protest was known or should have been known. This is generally based on the notice to the offeror that it has been excluded from the competitive range. There's one important timeliness trap to be aware of with competitive range protests. When an offer is removed from the competitive range, they're frequently offered either a pre-award or a post-award debriefing. The agencies will even sometimes remind the offerer that they'll receive more information in the post-award debriefing because it will include some basic information about the awardee that obviously isn't available in the pre-award debriefing. But while an offerer can choose to wait and receive a debriefing after award, it essentially waives its ability to protest by doing so. Deferring a required and offered pre-award debriefing does not extend the deadline for filing a pre-award protest of removal from the competitive range. So if the offer defers its debriefing until after award, then files a protest of its removal from the competitive range, that protest will be dismissed as untimely. I find this to be a particularly tricky area of the protest timing rules, so it's important to keep in mind when offered a pre-award debriefing after removal from the competitive range. Next slide. Under the Competition and Contracting Act, agency or GAO protests filed within certain timeframes trigger automatic stays of either award of the contract in a pre-award context or performance of the contract in a post-award context. Solicitation challenges filed prior to the time set for submission of initial proposals with the agency or GAO trigger the automatic stay, as do protests filed within 5 days of a required debriefing offered to an offer eliminated from the competitive range. It's important to note that, as in the post-award context, the pre-award post-debriefing timeline for getting the automatic stay is faster than the timeliness requirement overall. It's 5 days instead of 10. So a protester can timely file a protest within 10 days of the required debriefing, but unless they file within 5 days of that debriefing, they will not get the automatic stay. As mentioned, there are no automatic stays at the Court of Federal Claims. The protester must apply for and meet the standards for preliminary injunction. This requires the protester to show, 1, that they are likely to succeed on the merits of the protest, 2, that the protester will suffer irreparable harm unless the injunction is granted, 3, that a preliminary injunction will not harm the public interest, and 4, that the balance of the hardships tips in the protester's favor. This motion for a preliminary injunction requires briefing and frequently oral arguments, and it's a relatively difficult standard to meet. As mentioned, this is the primary reason that the court is a less popular venue than GAO. While we don't have all the statistics available from the court, GAO officials have been very vocal in recent months that the number of solicitation challenge protests have been on the rise. So this is a particularly timely topic for today's discussion, and I appreciate all of your participation today. Please feel free to reach out to me by phone or email if you have any questions. Mallory?
Thank you so much, Elizabeth, for sharing your knowledge and insight today. Today's presentation has been recorded and can be found on our website or YouTube channel within about 48 hours. If you have questions about today's topic, please contact Elizabeth at the phone number or email shown on your screen. Thank you, everybody. This concludes the webinar.